Court is calling 2025 CR 004086. All right, we're back on the record. Could I have parties announced for the state? Defense.
Anita Perez for the defense.
You're charged with assault, family, household, impeding breath or sex relation, and in cause number 2025 CR 004086. You're charged with violation of bond or protective order 2 times or more within 12 months.
Guys, today we're diving into a courtroom case that's got it all. Assault charges, protective order violations, and a defendant hoping charm will outweigh justice. From the jump, we hear felony charges carrying 2 to 10 years. The man accused seems confused, but the court isn't. This isn't some misunderstanding. It's a legal storm brewing, and the clock's already ticking.
Felony range of punishment in each of those cause numbers is anywhere from 2 to 10 years in prison and up to $10,000 fine. Plead guilty, not guilty, or no contest. All right. So in the cause number, and maybe I don't see it, in cause number 86, I don't see the other dates.
But those dates were down to which I just couldn't figure out how to put in these informations where those were days that the defendant called the victim from jail. So those we reported to jail.
All right. So
And we've been provided both those, Judge.
I'm sorry.
We've been provided those.
Well, are you stipulating that because he pled no contest? Is there a stipulation that he made phone calls to the complainant from the jail on December 6, 2024 and December 11, 2024?
So as far as that, Judge, we're pleading no contest.
All right, here's where things heat up. The defense pleads no contest, and suddenly jail phone records become the centerpiece. 2 separate calls to the victim while behind bars? That's a straight-up violation. Yet the lawyer still moves to waive a full PSI. Seriously? No investigation into a domestic assault case? That's not confidence, it's desperation dressed as strategy.
He is not native to Texas. He's from Indianapolis, Indiana. I'm sorry? Chicago, Illinois. I apologize, but he, as mentioned before, he's 27 years old. The victim and him are obviously very familiar. They've been together since they were children. So I think since they were like 16 years old. Is that right? 16? 15. Since they were 15.
Does he want to testify?
No, Judge. Let me just finish. I'm so sorry.
All right. So you can't get information from him, then turn back to the court to give whatever information he's given you if he's not going to testify.
Okay. I'll just proceed. Right. I'm sorry, Judge.
No problem.
And they do have 3 children together. And obviously they've had a myriad of things happen, I guess, in their lives, and they have both matured and progressed. And my client wishes to accept responsibility. He understands that the only way he's going to see his children, because that was another thing that we talked about, was that there will be a no contact order. That is something that
the defense spins a love story. Childhood sweethearts, 3 kids, shared history. But guess what? History doesn't excuse hands around a neck. We get vague statements about maturity, vague responsibility talk, and still no solid rebuttal to the chokehold. A romantic past doesn't soften criminal acts. The judge listens, but the emotional camouflage isn't fooling anyone.
He's in the waiting room or not, but notwithstanding, my client does want to go forward. His father obviously speaks very highly of him. Unfortunately, he did get arrested in February 27th, which is when he got booked for the last time. So he's been obviously in custody for almost going 3 months now. He's got health issues at the jail, Your Honor. He's got psoriasis. He lost about 110 pounds in those 3 months. So he's had some kind of health limitations. And so a lot of that is going into why we have this agreement. Obviously, I've explained to him multiple times, that we could ask for a jury trial from court. But, given the history with these people, that obviously he wants to accept responsibility, and he's wanting to do that today, Judge. And
Now we're in full sympathy mode. The defense cites jail weight loss and psoriasis like they're mitigating factors for violence. The man's health is declining, but so did the safety of his partner when he put his hands around her throat. He wants probation, but the only thing he's proven is a lack of remorse. Health conditions don't equal rehabilitation, and the court knows it.
today, we have, obviously my client hasn't had any contact with her since then. And then, but she has been in contact with the state, which obviously, you know, we know that is for a fact. But obviously, he's very concerned for his children. He wants to know their whereabouts, and he did meet with a recruiter, and I did speak to him on the phone. He would not come in for the PSI. His name is. Let me see. His name is Eggerson is his last name, Sergeant Eggerson, and I did call the number. Unfortunately, Mr. Ross was in the process of being recruited to the Army, and so obviously he understands that accepting responsibility for this charge, and should the court grant him deferred, he will not be able to possess a weapon while he's on deferred. But the hope, I guess, is that once he's completed the deferred, is that he'll be able to enlist at that time. So our agreement right now is 4 years. Now the court can give him probation, the court can sentence him, or the court can give him deferred, which I believe he's legally entitled to because he has no convictions.
What do you mean he's entitled to deferred adjudication?
Okay.
Legally.
Well, I would ask the court to take that into consideration, that he has no legal convictions. Under any other ordinary circumstances, he has no prior offenses.
Okay, but
convictions, and so
but if you're
he's
saying
a first-time offender,
all right. But if you're saying he's legally entitled to deferred adjudication on this case,
I have no statute.
Oh,
If the court, I have no statute, but I'm just saying, as a matter of principle, as a matter of mercy on my client, the court.
Things take a wild turn as the defense tosses out a military card. The guy met with an Army recruiter, so now he's a man on the path to redemption? Please. When you're facing felony charges and still pushing back on no-contact rules, waving the flag won't save you. Patriotism isn't a get-out-of-jail-free card. The court isn't here for theatrics. It's here for facts.
Because, again, he's also been in contact with being recruited, that he would be granted deferred adjudication. And, he wants to move on with his life. He wants to start probation. He understands that should the court grant him probation, he'll have to be here for 45 days, right? You understand? And that if he wants his probation to be transferred to Indiana, it'll have to be transferred within that time frame.
all right. So what I can
And
tell
he'll
you,
have to accept the
he's
transfer.
not a good candidate for probation.
He's not?
No, he's not. And let me just tell you why. Based upon everything that I've seen, there was a protective order in place, and you were calling the complainant from the Bexar County Jail. I mean, does he not understand what no contact means? No contact means no contact. And then we have this charge where you're choking her. So he's not a good candidate for probation. I'm not giving him probation. In each cause number, I'm finding him guilty. I'm going to sentence him to 4 years in the prison, give him credit for any time served. There's a $1,500 fine, time and money to run concurrent. The cases are to run concurrently. There's to be no contact with the complainant and no contact with minors. And cause number ending in cause number 2025 CR00.
Here's the classic move. He's a first-time offender. Give him a break. But that's not the flex they think it is. No prior convictions doesn't erase choking or violating court orders. It just means he got caught this time. The defense tries to turn that into a moral coupon for mercy, but the judge sees right through it. There's no discount on justice for good behavior in court.
They're going to take you back. If there's something else you all want to discuss, if you want to file a motion, you can file a motion and the court will hear that motion.
Can I please?
I don't know what you.
I just want to testify. I didn't.
Patrick Washington.
The courtroom tension climbs as the defense desperately pleads for deferred adjudication. Their argument? He's legally entitled. But entitled to what? Dodging accountability. The judge pushes back, demanding statute proof, and none comes. This isn't a debate class. It's a legal proceeding. The defendant's legal team is swinging hard, but the punches aren't landing.